Welcome to Divorce Dialogues. I'm Catherine Miller. Divorce Dialogues brings expert guests to the airwaves to talk through your divorce questions and fill in the gray areas about separating. From thinking about divorce to how to behave during divorce to what to do after, this is Divorce Dialogue. Welcome to Divorce Dialogues. I'm Catherine Miller. I am the founder of the Miller Law Group and a trainer at the Center for Understanding in Conflict, and I am on a mission to change how people divorce and help them divorce with dignity. And my guest today is Katya Sverdlov. I think I'm pronouncing that right, or close. She's an attorney and she's focused on estate planning and elder law. Katya has a background in finance and a deep commitment to client care, and she helps families plan ahead to protect what matters most. Welcome, Katya Sverdlov, to the show.
Katya, it's great. Thank you. Thank you so much for hosting me.
So let's go back to the beginning. I know that you walked away from Wall Street to start your own law firm. Was there a moment that made you say, I need to do this differently?
When I was in law school, I actually did my own estate planning with a large law firm. At that point, I was married and we had one child at that point. And I was not happy with the experience at all. I am a relatively educated person, and so is my husband, and yet we both walked out saying, we have no idea what just happened. Why did we need any of these documents? The documents had a ton of mistakes, like there were random people thrown in there that clearly the documents were not changed. No one explained to us what to do afterwards. And by the way, it has now been 20 years since those documents. Not once has that lawyer, again, in a very large law firm, has followed up with us to say, maybe you should update, maybe you should do things. There was nothing. I mean, I was charged a few $1,000s for that and given a package that I haven't looked since until I updated them myself. So I was so not happy, and I understand the importance of these documents that I wanted to do it better. And so when I started, after law school, I worked for a couple of other law firms, first learned. But when I was doing it, I decided to open up my own law firm. I wanted to do it better with the goal being people need to understand what they're doing. People need to understand why, need to make informed decisions. And it's my job to do that, to explain, to address, to explain to them issues that they may not even know about, that they have the issues, but people have to understand what and why, make informed decision, and then be informed on an ongoing basis as life changes, as laws change, as things progress, things need to be updated.
It's really interesting because I founded my law firm out of my own divorce experience. And so, very similarly to your story of founding your own law firm based on your client experience in estate planning. And so, I really appreciate that sort of turning it. There's nothing like being a client, right? To have you inform your feeling about how to be a better lawyer or any professional. And I know that you're not just a lawyer, you're also a chartered financial analyst. And I'm wondering how that combination of legal and financial expertise shapes your work with the people that you work with.
So, very intentionally, I do not give financial advice. I do not give investment advice. However, I am able to understand the financial portfolios that people have. And so it's quite helpful. Again, I understand the various real estate holdings. I understand the various business holdings that people have. I understand the implications of the tariffs and the economy and the taxes on their holdings. Understand the differences between the annuities, the multiple types of life insurance policies, all. And I don't think anyone can practice estate planning without understanding all of these things because people come with all of I mean, some people just say, I have 500,000 in a bank. That's fine. Some people I have $10 million thrown across multiple types of asset classes. What do I do? Some people say, well, I don't want to give it up just yet, but when do I do it? And so all of these issues come into play. Some people say, I want to leave IRA account to my daughter and my house to my son. Well, really, is that a fair division? Because by the time you die, you're going to deplete your IRA account if you live long enough, because you have to take RMD distributions from that account, whereas the house is likely to appreciate in value. So your daughter will end up having nothing, and your son will end up having a very nice $2 million house. Is that what you want? Maybe it is, but maybe it's not. Again, I want to make sure that people are going into with eyes open, understanding what they're doing, and people seem to be very grateful, right? That they come in with certain people come in with certain ideas, conceptions. Pretty much everyone says, well, two scenarios. People either come in and say, I have a very simple situation and I just want a simple will, or they run in screaming, I need a trust. Either way, before we get to the documents, we discuss what do you want? Talk to me in human terms. What are you trying to accomplish? And then we'll figure out what you need.
Yeah, that is very much our approach to divorce as well, because people think they need this and they think they need that. But thinking through the practical consequences, I want to stay in the house, right? Really? I mean, I get the emotional attachment to the house and the not wanting to move, change too much in your life at the same time. But really, let's look at the economies of that. Let's look at the cost of that. Let's look at the burden of being responsible for all of the repairs and anything that might come up. So, and I know that estate planning is also a very emotional process, right? So when people are thinking about, dying, it doesn't make them go, oh, goody two shoes. And people, they avoid it for a really long time. So how do you help? And what would you say to someone who's listening, who's hesitant or reluctant or avoiding having that conversation?
And I have this conversation quite frequently, and there are a few things. One, it will not get any easier. If you're avoiding it now, don't think that in 6 months or a year, the solution will be. In fact, it's going to get much harder. And I see that more and more, and unfortunately, it's the truth. After a certain age, even though somebody is considered to be mentally competent, people find it very hard to make decisions. Your mental capacity does decline. You understand that this decision is likely to be final and you're not going to be changing it later. And so the people's capacity for taking the just becomes that much less. So it will not get easier. At the same time, by not making this decision, you are making a decision. Right? So this is what, and so I explained, you don't have to. Absolutely, it's your choice again. And this is what is going to happen if you do nothing. And then we explain, this is it. This will be, one, there will be nobody in charge, right? Without a power of attorney, no, your husband, your wife, your adult child, your sister, just by you telling them, none of them have the right to make financial decisions for you. The judge is going to decide. Is that what you want? Do you want your family fighting in court over who loved you more or over who can argue better about your money? No. Do you want all in guardian? I do about a quarter of my practice is adult guardianships. And it's the worst thing that I do because all this dirty laundry has to be opened up in court. Is that what you want? No, then you have to name somebody who you love and trust, and or at least trust more than anyone else. Otherwise, the judge is going to decide after months of hearing about your incapacity. You don't want to decide how you leave money to your family? Then the law is going to decide. And this is what is law. And by the way, that brother that you haven't spoken to in 30 years, it doesn't matter. He's still considered to be your brother. Therefore, in New York, by law, no, I don't have a choice in this. By law, the brother that you haven't spoken to in 30 years has to be found, has to be served properly with the papers, and he has a right to contest whatever it is that you wrote improperly. Or if you did nothing, he's getting an inheritance. And there's nothing I can do. Oh, it's half brother. It doesn't matter. It's still legally considered your brother. If you don't like that, again, it's your choice. You can do nothing, and this is what is going to happen, or you do something. No, you don't like it, then we talk about something. So depends. And some people come, sign immediately and say, yes, please, can we get this done now? And some people delay, and then of course I get the horror cases. And then I talk about with changing of particulars, but I mean, like, and I don't have to make it up. This is what has actually happened in court. This is what has actually, is this what you want? No? Then we can do something to avoid it.
That's pretty compelling. I want to remind our listeners that I'm Catherine Miller, and you're listening to Divorce Dialogues, a podcast dedicated to educating people about divorce related topics so that everyone can divorce with dignity. Subscribe to the podcast wherever you listen to podcasts to be sure that you don't miss an episode. And I'm talking today with Katya Sverdlov about estate planning. And I think that estate planning is really part of getting divorced because whether or not you didn't have an estate plan when before you got divorced or you did have one, the two things really intersect with each other in a way that really is important for thinking about future planning. I think of divorce as being at the intersection between what was and what will be, and estate planning is definitely a part of what will be. And one thing that I think that people really worry about or try not to think about in the way, Katja, that we've been talking about people not wanting to think about their estate plan at all is planning for aging and long-term care. And I know that you do Medicaid planning as part of your practice. And I think that Medicaid planning sometimes sounds to people like, well, that doesn't apply to me because I'm not poor. But can you explain what that is and how that works for people thinking about their old age?
So Medicaid planning applies to about 70, 80% of the adult population in the US, as well as parents of children with special needs. So it's a large percentage of the
That is a large percentage. So if you thought, listeners, that it didn't apply to you, maybe perk up your ears.
for people that have total assets of roughly 3 million and below. Medicaid planning is a must. Why is that? It comes as a big shock to people. It's one of the biggest shocks that I constantly hear is that Medicare, which is what everyone has after 65 years of age, if you worked long enough in this country, Medicare does not pay for long-term care, period. Right. And like, what do you mean? I worked, or I work for the city, or I work for the DOE. I should have a pension. You do, and it's nice and it's lovely, and it does not pay for your long-term care. What is long-term care? It's home attendance if you want to stay at home and get help at home, or nursing home care, right? If you can no longer stay at home. How much is it? In New York, home care is about $10,000 to $15,000 a month. Nursing home is about $20,000 to $25,000 per month. So when you think about, oh, I have so much savings, great. Think about it. Usually people need long-term care for about 5 to 7 years of their life, potentially even longer if there's dementia or if there's Parkinson's or if there's a stroke. So if you're spending $20,000 a month, how much will your savings, how long will your savings last? Probably not that long, whatever you unless you're going to be selling your house. And then the question is, do you want to sell your house to pay for this care, or do you want to leave anything actually to your spouse who may not have long-term care, or your family or charity or anybody else? So again, once you go through this explanation, then the answer is, oh my God, yes, how do I protect my assets? So then the answer is, there are a couple of options. One, you can have long-term care insurance policy. And if you were smart enough and high earning enough to get it in your 30s and 40s and 50s, then maybe. But if you did not do that, as the majority of people did not, we're stuck, you're in the 70s and 80s, and you have your home and maybe $1 million worth of savings in the retirement account and savings account, and you're aging. What do? You need to protect your assets so that eventually you can qualify for Medicaid. Why Medicaid? Because it's the only one that pays for long-term care. How do you do it? You have to put assets into an irrevocable trust. And when I say that, people quite often taken aback. What do you mean irrevocable? That's what it means. You put it there and it's no longer yours. And so again, and the answer is, should I do it? The answer is it depends. I always ask, what is more important to you? Some people say, I want to keep the control of my assets for as long as possible. I don't have children, or I don't care about the children, or my children are fine enough financially. They don't need to get anything. I'm not doing it. Okay, that's absolutely the choice. You don't need to plan for Medicaid. Everything is going to be spent down for your care. It's an absolute choice. Or if you do want to leave something for your children and you want to make sure that they get the house, then the answer is you have to put the house into an irrevocable trust. It doesn't matter a house, an apartment, a co-op, your savings, whatever it is, it has to be put into an irrevocable trust timely. Because the other, as well, I'm perfectly fine right now. I'm a very healthy 75-year-old. I don't want to think about it. Great. Except that if you come to me 3 years later and you're already going into the nursing home because you had a debilitating stroke, there's going to be very little that I can do because there is a 5-year look back for these types of transfers. So I will be able to transfer assets then. However, for the next 5 years, Medicaid will not pay for nursing home care. So somebody, your family, your children, will have to be paying for them privately at $20,000, $25,000 a month, which is a lot of money. Do you think they'll be able to do that? Do you think they'll want to do that? No? Then we should start now. So again, it's people's choice, and there are some people that definitely make the choice saying, I'm fine with spending it down on my own. I don't care. And absolutely, but as long as it's an informed choice, then it's fine. So I don't push trust on everybody. Like I had a conversation recently. Somebody was recommended to me. They said, we heard that you say some people don't need a trust. I'm like, absolutely. Like, how is this possible? You trust an estate attorney. I'm like, again, I give you a choice. I give you an explanation, and then you choose. If you don't think you need a trust, you don't need a trust.
Well, that's very sobering, Katya Sverdlov. What are some of the biggest mistakes that, other than that, I guess, that you see people make when it comes to protecting their assets?
Well, one, many people think that because the estate tax is so high right now, they don't need to do anything and everything will be fine. And while you don't need to worry for the most part about federal estate taxes, because it does start now at $15 million, there are so many other considerations to estate planning other than taxes, right? One is, again, who is going to make decisions for you? I have, I would say about 20% of my clients have some family members that are unscrupulous. So the question is, do you want that unscrupulous child to get control of your assets? No, then you need to act proactively and make sure that someone else will be able to act on your behalf in case you're incapacitated or losing capacity. Right? So that's the biggest issue is make sure somebody who you trust will have access to your life in case of otherwise unscrupulous people do. And it doesn't have to be a child. It can be a sister, a nephew, anyone else. So that's one. Two is protecting assets from second spouses and protecting assets for prior children. One of people do things online and the documents look great, and I haven't seen them yet done properly. So when people get married for the second time, there are certain things that have to be done to ensure that children from a prior relationship actually get something without being proactive, because most people just do a simple will saying 100% to my spouse, if not to my kids, which works lovely if it's a first spouse and you have the same children. What if you don't? All of a sudden, your first kids got disinherited. And last but absolutely not least, when somebody is already suing you, it's too late to do a planning, right? It's too late to do. But it's funny, except that it's not. And I know that when somebody is running into the office or texting me or screaming, I need a trust immediately now, I always ask, are you getting sued already? If the answer is yes, I'm sorry, I don't want to lose my license and you don't want to go to jail. So at that point, it's too late. And just to get back to Medicaid as well, it's when some people reach out quite frequently and say, I'm calling on behalf of my mom. My mom needs to do a trust immediately. Like, great. Where's mom? Oh no, mom has dementia. Mom has dementia. She cannot talk. Like, Do you have a power of attorney? Are you allowed to say, oh, no, I don't have anything, but we need to protect? Well, it's too late. Before I can do anything on behalf of, and so people, it's definitely there for immigrants that in other countries, the power of attorney is not as important and adult children are able to act on behalf of the parents, can depending on the country. In the US, you cannot do that. No, if your mom has dementia and you don't have a power of attorney, before you can do anything on her behalf, you have to go to court and get a guardianship order, which takes months,
It's
$10,000,
costly. Yeah.
costly, embarrassing, could have been avoided with a proper power of attorney had she done it properly.
You're listening to the Divorce Dialogues podcast, and I'm Catherine Miller. Divorce Dialogues has been educating people about divorce and relationship issues for over 10 years. Subscribe to the podcast, and don't forget to check out our previous episodes on the podcast website, divorcedialogues.com. And I'm talking today with Katya Sverdlov about estate planning and the importance of it. And Katya, you have some very strong opinions. And if people want to hear more from you or contact you, how can they do that?
Please feel free to reach out to our office, 212-709-8112, or you can go on our website, sverdlovlaw.com. It'll be, I know the spelling is painful, but you can look in the notes and we'll be
Yeah.
happy to answer questions and to assist.
As Katja is saying, that the contact information will be in the show notes. One thing that I think is really a challenge, and I think my own parents are going through this right now, is as people age, the trying to preserve the sense of independence and autonomy and power over your own life and your own assets, but also protecting in the way that you've been talking about, Katja. So what do you say to our listeners about that delicate balance and how they should think about it?
It's a hard question, and there's no good answer. Unfortunately, there's no good answer. And people come to me and say, I want to have both. I want to have full control of my assets, and I want to have these assets protected. And I say, and I cannot do that. I can do a combination of the two, but unfortunately, and again, that's why I start. What are you trying to accomplish? What do you want? What is more important to you? And after we understand the goals, then we understand. But the irrevocable trusts do have some provisions there that allow the seniors to maintain some control over their assets. And those include the right to live in that house always. And again, very important because, and I always say that to seniors and I say that to the children, as long as mom is alive, you cannot kick her out of that house. I know the house is in the trust. Nope, you cannot sell the house with mom in the house because people have tried. People have actually tried doing this, and it's extremely sad and heartbreaking, and they cannot. So that's one. You have the right to live in the house for the rest of your life. Usually, also, people have some rights to change the distribution within the trust so that, again, they have some control. I always also say until you actually need Medicaid, don't transfer all of your assets into the trust. Keep some for yourself. You don't want to go to your children begging for $10 or $1,000 to go on vacation or to go to theater or to give a birthday gift to your grandchild. Keep some money for yourself. How much do you need? Again, it depends. Tell me about your lifestyle, right? What are you doing? Are you going to theaters? Are you traveling? Are you active, or do you stay home and once a week maybe go on a stroll? If so, you need less money. So it's really it's a combination of individual wishes, individual circumstances, and the situation. I mean, sometimes it's just somebody wants to maintain full control, but they're delusional and they're wasting assets by giving it to scammers. So, as sad as it is, despite their wish for control, it cannot be maintained.
Well, when you're working, Katja, with a multi-generational family and there's a dispute between the generations, I imagine that could be really emotionally complex. How do you handle that?
Individually, I also have to remember who is the client. right? Because I don't do mediation. I work with individual clients. So if the client is the child who's having a conflict with the parent, then I respect his interests and try to help him. If the client is the parent, of course, who is thinking of passing it along, then we focus on that. Again, the focus is always on don't talk to me about the documents. What do you want? And sometimes people actually quite often come in and say, I want to minimize taxes. I'm like, I agree, and it's an important consideration. Is there anything else that you want to do? Do you want to ensure that your two children are not fighting? Do you want to ensure that the business actually continues to run? Because that's an important consideration versus do you think it's just going to shut down after you? If you do want to ensure that the business continues to run, so then let's talk about it. Who is in the business right now? Oh, it's only one out of three children. Do you really think it's fair to that child who's in that business to leave it equally to the other two? Maybe, just maybe, there are ways of doing it otherwise, right? I understand you want to leave them money, but we can leave them a life insurance, we can leave them cash, we can leave them some payouts, but really the one that is in charge already and helping you out, I think it would be fair to give more control to him. And so again, we discuss what is more important. Do you want to make sure that your second beautiful young spouse is actually getting protected and will be taken care of? Okay, then we need to act. No, they're not going to like her. No, they will kick her out of the house unless you specify that you don't want that happen in writing, not just in your precatory wishes. So most of the time I focus on, again, don't worry about the legalese. We'll get the human. Tell me what you want.
That's great advice. We're almost out of time, Katya, but what's one thing that you wish every family knew about estate planning, but that most don't?
Verbal advice, verbal suggestions, unsigned documents do not work in no states. The most common things, I told them what they want, this is what they're going to do. No, they will not. Because they will have no capacity of doing so. Not because they're evil, they will have no ability. It will go based on the documents that you've actually properly signed or based on the law. Whatever you tell verbally, especially in the state of New York, but pretty much all over, will not work. It has to be done properly in writing.
Well, Katya Sverdlov, thank you so much for being my guest. I think in that last point, what you're saying is that you need to follow through. You need to work with someone who really knows what they're doing to make sure that your wishes are properly documented and properly executed, which means signed in the right way. And so I appreciate your passion for the work that you do and your commitment to helping your clients get what they want. Thank you so much.
Thank you. Thank you for hosting me.